India Legal presents Courts Roundup.
Hello, I am Tanya and you are watching Courts Roundup. In this program, we bring you the latest legal news and details of court proceedings. Before we begin, here are the headlines. Delhi High Court seeks AAP government response in challenge to order capping price of Covid RT-PCR test at ₹800. UP government's controversial ordinance against religious conversions challenged in Allahabad High Court. Plea says law against personal liberty is unconstitutional. Allahabad High Court seeks response from the Election Commission on the issue of banning BJP from using the lotus, the national flower, as its party symbol and its allocation for elections. Karnataka High Court has granted bail to Kannada film actor Sanjjanaa Galrani, who was in custody in the famous Sandalwood drug case. She had sought bail on medical grounds.
India Legal presents Courts Roundup.
The Supreme Court bench, headed by Justice Uday Umesh Lalit, has remarked an order while appreciating the presentation by a state counsel Sumeer Sodhi, who submitted convenience notes. The bench said that this is how a case can be presented on behalf of the state advocate Sumeer Sodhi had appeared on behalf of state of Chhattisgarh in a criminal appeal preferred by the accused in a murder case. The court in its judgment reproduced a convenience note submitted by him in which he briefly and succinctly described the details of FIR, accused persons, history of proceedings and also the legal submissions on behalf of the state.
Convenience note submitted by Chhattisgarh government's standing counsel Sumeer Sodhi in murder case before the Supreme Court came in for special praise by the top court, which not only lauded the format of the note adopted by the lawyer but also suggested counsel for other states to follow the format. The three-judge bench headed by Justice U. Lalit cited the format of the note, stating that it was an illustration of how a case can be presented on behalf of the state. The bench also comprised Justice Vineet Saran and S. Ravindra Bhatt, directed that the copy of the order passed by the court in which the note was extracted in its entirety be circulated through standing counsels of all states in the Supreme Court. We must observe that the presentation made by Mr. Sumeer Sodhi in the note extracted above is an illustration how a case can be presented on behalf of the state. We may suggest that the said note may be taken as the standard format by all learned counsel appearing for various state governments in the state. The registry may circulate copies of this order to all learned standing counsels for the state. The court said in its order. Advocate Sodhi in his convenience note had in a tabular format given details of FIR, accused person, history proceeding and also legal submissions on behalf of state. Sodhi appeared on the behalf of state along with Advocate Ridhima Juneja. The court, with the help of convenience note, came to the conclusion that the case of three appellants was on the same footing as that of the four other co-accused who were early acquitted, the case involving charges of murder under Section 302 of IPC and causing voluntary hurt. With the assistance of the learned counsel, we have gone through the record and are satisfied that the role attributed to the present appellants was not in any way different from that attributed to the other four acquitted accused, said the bench. The court therefore allowed the appeals and set aside the conviction and sentence handed down to the accused. Bureau Report.
The Supreme Court dismissed a plea seeking handing over the 1993 Vora Committee report on criminalization of politics to central agencies, observing that such a prayer was utopian in nature. The court was hearing the plea filed by BJP leader Ashwini Upadhyay, seeking a direction to the centre to hand over the 1993 report to the National Investigation Agency, the Central Bureau of Investigation, the Enforcement Directorate, the Intelligence Bureau and the Serious Fraud Investigation Office, among others, for a comprehensive probe into the criminal politician nexus. The bench of Justices Sanjay Kishan Kaul, Dinesh Maheshwari and Rishikesh Roy, while rejecting the petition, granted liberty to the petitioner to approach the Law Commission of India. I hope country will be at the top. I hope world is a beautiful place. The prayers are like these. One can understand giving a nudge to the centre, but I cannot encourage petitions like these. These are all utopian prayers, Justice Kaul remarked. Upadhyay had sought concrete action on the report submitted by then Union Home Secretary N.N. Vohra on the alleged link between crime syndicates, politicians and bureaucrats. He urged the top court to direct the government to reveal the names of the criminals, politicians and public servants against whom there was tangible evidence in the report and set up special courts to expeditions, try all cases referred to in the report. The petition, placing reliance on the report, said that mafias, smugglers and money launderers had developed an extensive network of contacts with bureaucrats, government functionaries, politicians, legislators and strategically located personnel in the non-governmental sector. The Supreme Court listed for hearing in January 2021 the Union of India's appeal against the Bombay High Court direction to the centre to revise a convict's release date by taking into consideration the adoption of the sentence in terms of Section 13(6) of the Repatriation of Prisoners Act 2003 and order his release after calculating his date of release. The bench, headed by Justice A.M. Khanwilkar, was hearing the centre's SLP against 2019 Bombay High Court judgment, allowing a petition filed by one Sheikh Ishtiaq Ahmed, who was lodged in Thane Central Prison after being convicted of being a drug trafficker by the Supreme Court of Mauritius in 2014 and sentenced to 26 years in prison. Taking into consideration the fact if the same offence committed by petitioner in Mauritius was committed in India, he would have been imposed a penalty prescribed under Section 21B, and in such circumstances, the compatibility of the sentence would not only require compatibility of duration but also the nature of the offence. The mere reason that if the prayer of the petitioner is granted, it would amount to reduction of sentence by 16 years cannot be valid justification for rejection of the prayer of the petitioner on Thursday. The bench, also comprising Justice B.R. Gawai, agreed to hear the matter in January, keeping the plea for ad interim bail deferred until then. The Delhi High Court issued notice in a challenge to Delhi government order capping the price of RT-PCR test for COVID-19 by private laboratories at Rs 800. Under the order, the price of test involving home visits is Rs 1200. A single judge bench of Justice Naveen Chawla sought response from the Aam Aadmi Party government in a petition by Association of Practicing Pathologists, who is the petitioner. As per the petitioner, the government order violated Article 14, 19(1)(g) and 21 of the Constitution of India. The court was also informed that a petition concerning price fixation of RT-PCR test was already pending before the Supreme Court. The Delhi High Court on Friday stayed the operation of the order passed by the Central Information Commission directing the Indian Air Force to divulge under the Right to Information Act information relating to Prime Minister Narendra Modi and former Prime Minister Dr. Manmohan Singh's entourage on foreign trips. The stay order passed in a petition filed by Air Force challenging the CIC direction.
The Delhi High Court has stayed a Central Information Commission order directing the disclosure of information about the foreign visits undertaken by Prime Minister Narendra Modi and former Prime Minister Manmohan Singh. A single judge bench of Justice Naveen Chawla issued notice in the challenge preferred by Central Public Information Officer, Directorate of Personal Services, Air Headquarters, Indian Air Force, who is the petitioner, and sought response from RTI applicant Commodore Lokesh Batra. Appearing through advocate Rahul Sharma, the petitioner argued that while information on the number of flights visit had already been provided, the information sought by applicant with respect to the entourage was extremely sensitive in nature. Specifically opposing the disclosure of names and designation of persons and security personnel accompanying the Prime Minister, Sharma contended that the information had nothing good for the applicant. Sharma argued that information on Prime Minister's Special Protection Group was exempted from disclosure under Section 8 of the Right to Information Act. In view of CIC order, the court suggested the petitioner to disclose the number of persons who accompanied the Prime Minister and withhold details of persons occupying sensitive positions. The CIC sent the ball to your court to see what can be given. The court remarked, being identified information that could or could not be shared under Section 8 of the Act. Advocate Prasanna S. opposed the petition on the ground that it was misconceived and that the Chief Information Commission order was passed on the petitioner's undertaking. In its order, CIC directed the petitioner to provide certified copies of available and relevant flight records sought by the applicant after severing the names and other relevant identifying particulars of the security SPG personnel. The matter will be heard next in April 2021. Bureau Report.
Delhi High Court has sought Centre's response in challenge to power to arrest under CGST Act. The petition also seeks a direction that the mandatory procedure under Chapter 12 CRPC should be followed for a valid commencement of an investigation.
Delhi High Court has issued notice to the central government in a petition challenging the power of arrest given to Central Goods and Service Tax officers under Section 69 of the Central Goods Service Tax Act 2017, while challenging Section 132 of the CGST Act on punishment for certain offences. The petition also seeks a direction that the mandatory procedure under Chapter 12 of the Code of Criminal Procedure 1973 should be followed for a valid commencement of an investigation. The matter was heard by Division Bench of Justice Manomohan and Sanjeev Narula. The petitioner, one Arun Gupta, is the director of a company under investigation by Directorate General of GST Intelligence, New Delhi. The petitioner has alleged that earlier this month the CGST officials conducted a search at the company and brutally slapped and manhandled one of the employees. Subsequent summons were issued to the petitioner and an accountant of the company under Section 70 CGST Act 2017. In view of the initiation of an investigation against him and his house being sealed, the petitioner approached the High Court to safeguard his fundamental rights and seek adjudication of important and substantial questions of law of great public importance. As per the petitioner, Section 69 is unconstitutional as an arrest under it has no constitutional backing under Article 246A. Any arrest under the section thus violates Part 3 of the Constitution of India, particularly Article 21, the petitioner has asserted. The petitioner states that since the offences alleged or suspected under the CGST Act are non-cognizable, a citizen can neither be arrested without warrant issued by any court nor can officers commence investigation without the order of a magistrate. The draconian provision of CGST Act give a lot of discretion to the officers, which is in violation of Article 14 of the Constitution, the petitioner asserts. Before the court, the petitioner showed that he would cooperate in the investigation. Bureau Report.
A writ petition has been filed before the Allahabad High Court challenging the constitutional validity of the UP government's controversial ordinance against religious conversions in the name of love jihad. Advocate Saurabh Kumar has moved the High Court stating that the Uttar Pradesh Prohibition of Unlawful Conversion of Religion Ordinance 2020 is both morally and constitutionally repugnant. He has urged the court to declare this law as ultra-vires the constitution and in the interim direct the authorities not to take any coercive action in pursuance thereof. The petitioner has submitted that the passing of the ordinance could satisfy the first condition of legality. However, the state action falters when it comes to the test of need and proportion, proportionality. It is submitted that provisions give the state policing powers over a citizen's choice of life partner or religion and thus militate against the fundamental rights to individual autonomy, privacy, human dignity and personal liberty guaranteed under Article 21 of the Constitution. Taking exception to this, the petitioner has submitted that very concept of forcing an individual to explain and justify a decision which is closely personal to him or her before an officer of the state is contrary to constitutionalism. It may be noted that this ordinance, along with Uttarakhand Freedom of Religion Act 2018, have already been challenged before the Supreme Court. The PIL praised that these laws made in the name of love jihad be declared null and void because they disturb the basic structure of the Constitution. We are joined by Advocate Shivam Sharma. Shivam, please tell us about this case.
Yes, in this case, the petition states that obligation to seek permission for conversion 2 months in advance is fundamentally arbitrary and a violation of the right to privacy. Plea further points out that Section 12 of the Ordinance reverses the burden of proof in as much as a person who was caused the conversion is liable to prove that such conversion was not effected through misrepresentation. The petition also said that the Constitution imposes limitations on the state power and burdens the state to explain and justify the decision taken by it affecting the rights and lives of citizens. The court in this case has said that the right to live with a person of his own choice is irrespective of the religion preferred by them is intrinsic to right to life and personal liberty. Yes.
Thank you, Shivam, for joining us. The Allahabad High Court has sought a response from the Election Commission of India on the real issue of banning BJP from using the lotus, the national flower, as its party symbol and its allocation for elections. The issue has also arisen in the court that relaxation of election symbol by political parties for campaigning as a logo will discriminate against independent candidates. The petition states that the Election Commission has the right to allot election symbols to a national political party to contest elections under the Representation of the People Act 1951 and Election Symbol Reservation and Allocation Order 1968. The Election Commission has the right to withdraw the party's recognition if it violates the Model Code of Conduct. The BJP's election symbol is India's national symbol lotus and therefore it should be banned from confiscation and misuse. The court has allowed the petitioner to make any other political party as a party in the petition. The court said that the issue has not been raised in the petition, that the election symbol is allotted only for the election, not for any other purpose. So why is the election symbol being allowed to be used for other purposes? The petitioner advocate asked why the election symbol is allotted to the contesting candidate. The Election Commission advocate asked for time to consider these points, to which the court has given time to file a reply. The petition will be heard next on January 12. The Karnataka High Court has granted bail to Kannada film actress Sanjjanaa Galrani, who was in custody since September 8 in the infamous Sandalwood drug case. She had sought bail on medical grounds. Justice Srinivas Harish Kumar granted bail to her subject to execution of a personal bond of Rs 3 lakh and 2 sureties of like amount. She has to mark her attendance twice every month with the probe agency and has to cooperate with the investigating agency. Senior advocate Hashmat Pasha, appearing for Galrani, told that the court has rejected the submission of the prosecution that she can be treated in the prison. The court had earlier directed for the conducting a thorough medical checkup of the actor by doctors of One Vilas Hospital to assess her health condition and submit the report on November 3. The High Court had denied bail to actors Ragini Dwivedi and Sanjjanaa Galrani and other accused persons who were arrested in the Sandalwood drugs case. The actors, along with others, have been charged under various sections of IPC, including 120B, Criminal Conspiracy, and the Narcotic Drug and Psychotropic Substance Act of 1985, under Sections 21, 21C, 27A, 27B, and Section 29. Ragini was arrested on September 4 while Sanjjanaa was arrested on September 8. The drug case came to light in September when the Narcotics Control Bureau arrested a person who had revealed how high-profile drug parties were organized in Bengaluru. Nothing that criminal cases suffer because of lack of adequate investigation, the Calcutta High Court observed. It is high time that police reforms are introduced in this state to bifurcate the law and order wing from the investigating wing. The bench of Justice Sanjeev Banerjee and Justice Arijit Banerjee was hearing a case of missing girl, wherein despite time being afforded to the state, it further sought time to locate the missing girl. In Prakash Singh's case, the apex court had instructed central and state governments to comply with a set of 7 directives related to operational reform and functional autonomy of the police. The apex court had also said that there should be a public complaints authority at district level to examine the complaints from the public on police excesses, arbitrary arrests and detentions, false implications in criminal cases, custodial violence, etc. And for making necessary recommendations in June 2020, an application was filed before the Supreme Court suggesting measures for speedy and effective implementation of the Prakash Singh ruling for systematic police reforms. Recently, Madras High Court took note of the suicides and desertions within the police force while observing that there is no mechanism available in the police force, and that is the reason why so many genuine grievances of the police could not be addressed. In a curious development, a sessions judge in Jammu and Kashmir rescued from hearing an application for anticipated bail, saying that he got a message on behalf of High Court judge regarding the order to be passed in the case. The principal sessions judge, Srinagar Abdul Rashid Malik, made a bold move by naming the High Court judge and also his secretary in the order. In a written order passed on December 7, the sessions judge said that Mr. Tariq Ahmed Mota, the secretary to Justice Javed Iqbal Wani, judge of the Jammu and Kashmir High Court, had telephoned him to convey the directions of the judge to make sure that no bail was granted to the accused who was seeking anticipatory bail. The order recorded the contents of the phone call as follows. I have been directed by the Honorable Mr. Justice Javed Iqbal Wani to convey you to make sure that no bail is granted to Sheikh Salman. If there is any anticipatory bail pending, the direction is the same. The order was passed in the case Sheikh Salman v. Juk, where the accused was alleged of offences of attempt to murder, wrongful restraint and hurt under section 307, 341 and 323 of the Penal Code. Following this, the sessions judge expressed his inability to hear the matter and said in an order dated December 7th that this application is submitted to Learned Registrar Judicial High Court of Jammu and Kashmir with the request that the same may be placed before Honorable the Chief Justice as the matter involves the liberty of the person. As per case records, the bail application was transferred and posted before the 1st Additional District and Sessions Court on December 11. The accused was granted anticipatory bail by the 1st Additional Districts and Sessions Court on Wednesday. That's all for Court Roundup today. Thank you for watching APN.
India Legal presents Courts Roundup.